Welcome to the NC DWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NC DWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 127 of the NC DWI Guy podcast. On today's episode, we are talking about the impact of refusing a chemical test in the courtroom setting, in the criminal context. So back on episode 72, we talked about refusal hearings. So basically, refusal in the context of a DMV hearing, in the context of a license revocation based on the refusal. But today we're going to talk about it in the courtroom context and how it is used. One thing that I have noticed, and this is not something that is specific to any jurisdiction or any particular part of the state, there are certain judges that I think put a lot of weight into a refusal of your client of chemical testing, whether that's blood or breath testing, put a lot of weight into that in the determination of guilt. And so what we're going to talk about today are some of the reasons why a willful refusal is important, and then some of the things to bring out to a judge or to the jury in the superior court setting regarding refusal, why that might have happened, what was going on at the time of the refusal, and what your client's rights are related to refusing a chemical test. So why is a willful refusal important? What is the importance of a willful refusal? If you have a client that calls you on the phone, got arrested last night, charged with DWI, was offered a breath test, I refused, what bells should be going off in your head? Well, we're going to talk about a couple of them. So again, number one consequence is that there could be a 1-year suspension of the driver's license. Under 20-16.2 subsection D, that speaks to the consequences of refusing chemical testing. So by implied consent, when there is a rights form read to your client, whether it's for blood testing or breath testing, these are the consequences license-wise of such refusal. So look to 20-16.2 in terms of determining how your client could appeal a refusal suspension, what the process is in terms of the hearing and what things that can be brought up during that. We did a episode on this kind of entire license revocation back again on episode number 72. So we're not going to get much into that today, but certainly that 1-year revocation should be front and center in your mind. If you have a client that says the officers told me that I would refuse chemical testing, regardless of whether they meant to, whether they didn't intend to refuse, whatever the situation may be, you need to put on that client's radar front and center that they may be revoked for 1 year for a license suspension, and that they need to have their eyes peeled for a letter from the DMV regarding willful refusal suspension. Make sure that they are aware that that could be coming down the pike and what to do in the event they receive that letter. The other license side of things, and this is, as we know, immediate, is the 30-day civil revocation that could come from willfully refusing under 20-16.5. So in addition to the 1-year suspension, your client could also be facing the normal 30-day immediate suspension of the license. This is always particularly important for CDL holders. So just make sure that in terms of contesting the civil revocation, that you know what the time frame looks like for that and how to go about contesting the 30-day civil revocation under 20-16.5. So Number 1 and 2 are both, again, kind of DMV consequences. We're not going to spend much time on that today. Number 3 and 4, we are going to spend a little bit of time talking about. So, first of all, in the courtroom context, a willful refusal of a breath test makes any prior result admissible, any prior number that was blown admissible. So under 20-139.1 B3, 20-139.1 B3, that section says that a person's refusal to give the sequential breath samples necessary to constitute a valid chemical analysis is a refusal under GS 20-16.2. And as such, if there is a refusal that allows for that prior sample to be given, that prior example becomes admissible. So if you have a situation where your client has blown whatever the number comes back at, that, let's say it comes back, the first breath test comes back at a 0.15. Subsequent to that, whatever additional blows are rendered, or the person just says, I'm not going to blow anymore, the officer indicates a willful refusal at that time, then that first number is coming in. So this is like the worst of all possible worlds for your client, generally speaking, because not only does the state now have like a number to go off of, but they're also going to have a potential 1-year suspension of the license hanging over your head. So there's all kinds of different factual scenarios where this kind of subsequent breath test situation arises. So you have somebody that goes into the jail after being arrested for DWI. They're advised of their rights under 20-16.2 by the officer. The officer gets 1 breath sample and then subsequently indicates on the test ticket that there was a willful refusal. This is a situation that where there are the right facts, you should look very heavily into suppressing the willful refusal notation, because it really is the officer indicating a willful refusal. And what I have seen over years of practicing is that oftentimes where an officer has had a struggle getting an initial breath sample, and they finally get that initial breath sample, they are pretty quick on the trigger to indicating a willful refusal. Now, why is this? Well, probably in part because they are fed up with your client not rendering a sufficient sample. Generally on a test ticket, on any given breath test, generally in the time that the test is set up to the time that it times out, there is typically anywhere between about 3 and 5 breath samples that can be given during that time range. And then every time that the test times out, you got to start over in terms of the operations of reinitializing the intox machine. So that takes additional time. And so if you have somebody that has gone through a full test ticket cycle, hasn't been able to get register a sufficient sample, and the officer is either getting frustrated about that or thinks that your client is trying to manipulate the test, their patience is already wearing thin. Now they reinitialize the test and they try again to get a sample. Maybe the first 2 samples are insufficient. Finally, on the 3rd sample, they get a reading. And then again, the test times out. Well, by this point, they've already done like 2 series of the test ticket. The officer's patience a lot of time is worn thin at this point. And so what I tend to see is that where there is this 1 sample registered and then a second sample not received, an officer indicating willful refusal, is that it's taking a long time for that first sample to get collected, then a very short period before the willful refusal. Now, why is that? Because every officer, at least very, very vast majority of officers, know that if they issue a willful refusal under those circumstances, that initial result, that first result, is going to come into evidence. They're aware of that. That is something that is taught during their training. So they know that that number is going to come in. So and this is not the right argument if you have a situation where your client blows, sees the number on the test ticket, and is like, "Oh crap, I'm not going to blow anymore." That's a rough spot. There's not really much of an argument to be made there. But where the person continues to try or to appear to try, I think one argument that you should absolutely be making is, Trooper Jones, how many times did it take for you to get a sufficient breath sample the first go around? How many times did the person blow? Well, Mr. Minnick, I don't remember exactly how many times your client blew, but this sample was registered on the second test ticket. Each time we run the intox, there's probably time for about 3 or 4 samples to be given. So on the first ticket, 3 or 4 samples, and then I don't know exactly when this was blown on the second test ticket, but took a while for us to get that initial sample. And I've seen it take to the third test ticket before a sample is rendered. So, anywhere between, 7, 8, 9 tries before that first sample is getting rendered. So bring that out. How many times did it take for that first sample to get? How many additional opportunities did you give to my client to get a second breath sample? A lot of times the answer is going to be much fewer. Well, maybe 1 or 2. Why, if it took 4 initially, did you only wait 1 additional sample before deciding that there was a willful refusal? Why did you indicate my client was willfully refusing? Was my client attempting to blow? Did my client tell you they weren't going to do the test anymore? Now, you're going to hear some answers such as, didn't think that he was following instructions. Your client was blowing out of the side of his mouth. He was, the defendant was not putting properly sealing. I could tell that he was actually not blowing into the device based on the sample of breath, the amount of air that was going into the intox according to the intox kind of measurements that it was taking in terms of the breath volume. So you're going to have some of these type of answers, but I think it's important to say, but you were able to get a sample, and it took a number of tries to get that sample. It took a number of tries to get to that point. Once that once that first number was registered, it was a lot less samples, a lot less opportunities that were given to blow before you indicated a willful refusal occurred. So if your client did not actually tell the officer after the first sample was registered, "I'm not blowing anymore," then you need to ask about how many additional samples were attempted after the first actual result was collected, because I think that can show the judge, Your Honor, there was a lot of opportunities given to get that first sample, but then very few after that. And the reason why? Well, because officer knew that first sample is coming into evidence if the refusal was entered. So bring that point out. Something that's always helpful with these type of scenarios is to try to see if there is any body camera that captures this interaction. If you've got a willful refusal, making sure that the rights are properly advised, how the officer is explaining anything after he reads the rights in terms of what the next steps would be, what does it mean to willfully refuse, how the officer is instructing about how to conduct the intox test and telling your client how to do the test, specifically how many blows are being done, each and every test ticket. You can see all of that on video. So that could be very powerful to your position. Could also be very damning to your position. So again, don't assume that it's going to be helpful to get that. But at the same time, having the video back of what's going on inside the intox room can be extremely beneficial in terms of attacking a willful refusal. So in terms of one of the consequences of refusing chemical testing, talk about that to the judge. If you've got a result that is followed by a willful refusal, attack the willful refusal, because if you're successful in saying, there just wasn't sufficient additional opportunity, my client never told him that he wasn't trying to blow. He had already been able to blow one time. He was willing to give additional samples. If you can undermine the willful refusal, not only does the willful refusal not get the ability to be used by the DA as any evidence of impairment, but you also are going to be able to exclude that number from coming into evidence, which could be huge. I mean, it could mean, very, very much the difference between a guilty and not guilty verdict. The kind of fourth major importance of an officer's indication of a refusal is how that can be used in evidence. And this is our last point of the day, but we're going to spend a good amount of time here. So under 20-139.1F, it says evidence of refusal admissible. This is coming from the statute. If any person charged with an implied consent offense refuses to submit to a chemical analysis or to perform field sobriety tests at the request of an officer, evidence of that refusal is admissible in any criminal, civil, or administrative action against the person. So if any person charged with an implied consent offense refuses to submit to a chemical analysis or to perform field sobriety test at the request of an officer, evidence of that refusal is admissible in any criminal, civil, or administrative action. So it's admissible evidence. It's admissible evidence. Now, where I tend to see a issue with this is just kind of in this assumption that this is automatically evidence of guilt. And I think, again, I see a fair amount of judges in my career have put, I would say, a lot of weight into the refusal as evidence of guilt, that this is strong evidence of guilt. So what should this be used for? Well, let me read from the pattern jury instruction that gets read to a jury on how to interpret this kind of refusal of chemical testing. So this comes from North Carolina pattern jury instruction, Crim 270.20A. So this is the pattern jury instruction for misdemeanor impaired driving. So in that instruction, if there is a refusal of a chemical test or of standardized field sobriety test, here is the pattern language that the judge can read. If the evidence tends to show that a chemical test, known as generally either a intoxilizer or a breathalyzer blood test, they can kind of fill in the blank there. A chemical test known as, let's say, a blood test was offered to the defendant by a law enforcement officer, and that the defendant refused to take the test, or the defendant refused to perform a field sobriety test at the request of an officer. Here's the important language. You may consider this evidence together with all other evidence in determining whether the defendant was under the influence of an impairing substance at the time that the defendant allegedly drove a motor vehicle. So again, how is this refusal of chemical testing or of standardized field sobriety testing to be taken by the jury? You may consider this evidence together with all the other evidence in determining whether the defendant was under the influence of an impairing substance at the time the defendant allegedly drove a motor vehicle. And so what I kind of see a lot of times in refusal cases is there's not a lot of other evidence of impairment. Again, every case is different. Sometimes you're throwing a case up and whatever you can put in front of the judge, maybe there's a lot of other evidence of appreciable impairment. So not a good example in that context. But if you have a client that does reasonably well on field sobriety tests, no slurred speech, no difficulty standing up, a lot of evidence of sobriety, what I have seen is that, okay, from the judge's perspective, if there is a refusal, that means he's guilty. That means your client is guilty. Remind the court of that pattern jury instruction, that the evidence of refusing is to be taken together with all of the other evidence in determining whether or not your client was under the influence of an impairing substance. And so what does that ultimately mean? Well, it's kind of basically at the end of the day, and I used to kind of get nervous about this instruction in a refusal case, but it's somewhat of a meaningless instruction, because what does it say? It basically says, take all of the evidence that you've heard to determine whether or not there was guilt or not guilt. That's what it says. Take all of the evidence. And so it is a little bit of a misleading instruction to some extent, because it says, take this piece of evidence specifically along with every other piece of evidence to determine guilt. Well, what does that say? What does that ultimately boil down to? Look at all the evidence. So it's kind of a meaningless instruction, because if you really look at the instruction, it's basically ultimately telling the jury, take all of the evidence into consideration in determining whether or not somebody is driving while impaired, which is what the jury's job is. That's what they're supposed to be doing. They're supposed to look at all the evidence. Yes, they can look at the refusal, but they're also very much supposed to be focused on what is the evidence of sobriety? What is the lack of evidence of impairment, right? So remind the court of that instruction in terms of looking at all of the evidence. And certainly if this is a case in front of the jury, remind the jury of that specific language, that they're to look at all of the evidence. Now, one thing that I would also point out is that in a situation where there is a refusal given implied consent. So what we're talking about today is implied consent refusal. We're not talking about the situation where a blood warrant is drawn by the officer. They legitimately go through the process. They get a search warrant to draw blood, and your client says, over my dead body, are you taking my blood? And ultimately they don't take the blood. That's not really kind of the focus of today's episode. In today's episode, we're focusing on implied consent refusals, where there is a request for a consensual chemical analysis, and the officer says, defendant refused to give a blood sample, breath sample, whatever it might be. So in the situation where there is this implied consent refusal, talk about the language that is in 20-16.2. The person is told before they give any sample, you have the right to refuse, right? You have the right to refuse. That's important, right? I mean, this is the officer that is reading to them, one of your rights in this particular scenario is to refuse chemical testing, right? And they say, but your license could be suspended for up to a year. This could be used as evidence in a criminal proceeding, this refusal, but they explain this is one of your rights. Okay, and it's really the first thing that they read off of 20-16.2. Number one, this is 20-16.2A, subsection number 1. You have been charged with an implied consent offense. Under the implied consent law, you can refuse any test. under the implied consent law, you can refuse any test, right? So they tell the person that they can refuse any test. So remind the jury that this is a right that the person was told about, and it's the first thing that they're told about. Now, what is typically not kind of gotten into by the officer when they ask, will you do a breath test? Will you allow us to take your blood by consent? Normally, the person just says no, or maybe there's a couple of questions asked, but normally they just say no. Sometimes they explain why they're doing that. But whether the motivation for not taking the test is expressed or not, that is something to communicate to the judge or jury. And let me give you a specific example of this. One thing that I see repeatedly argued in closing related to refusal by the state is that, this person refused to submit to a chemical analysis of their breath, and they knew at the time that they refused that their license was going to be taken for a year, and they still refused. Now, to some extent, that's a legitimate point. But what about in a situation where you have a client that does not have an operator's license? If you've got a person that's charged with DWI and no operator's license, make sure that you bring out, don't plead guilty or try to get the no operator's license dismissed as a meaningless charge for the most part in these kind of situations. If you've got a DWI, that's the more important charge. Make sure that evidence of no license comes out. Why? Because it makes the consequence of refusing completely meaningless. Totally meaningless. And I've argued this on a number of cases where my client did not have a valid driver's license for whatever reason. If you can get that to come out, Officer Jones, when you stopped my client on the side of the road, did you ask him for his license? Yes, I did. Did he give you one? No, he didn't. Did you ask him why he didn't give you one? Yes, I did. Why didn't he give you one? Why did he tell you he couldn't give you one? He said he didn't have one, right? If you don't have a driver's license, it's pretty meaningless to tell somebody that doesn't have a driver's license, we're going to take it away from you for a year, right? So it makes that decision much more mitigated in terms of being a kind of like, aha, you're willing to lose your license for a year in order to avoid giving us a breath sample, right? It's meaningless. It'd be like, telling your child that you're going to take their Halloween candy away because they've been bad when they already ate all the Halloween candy. It's like, all right, go for it. Take all the Halloween candy away. I don't care. It doesn't matter. It's wrappers at this point, right? For the person with no operator's license, it's wrappers. I mean, there's no consequence to that. And that should be helpful because you're telling the judge it doesn't matter. Like this person didn't have anything to lose by refusing. The other thing that is important to tell is I have heard a lot of times in a breath test room, and it'd be interesting to see at some point, maybe we'll all be in the same room together. Everybody that's on the other side of this listening, and maybe we'll all be in a room and I can ask everybody, how many clients that have ever lived in Florida tell the officer that they've heard to refuse? Because I swear that this is some sort of like basic birthright in the state of Florida, that if you grow up in Florida, somehow it is like common knowledge that you should refuse the breath test. Every time I've got a client from Florida, hey, you should definitely refuse. That's just what it is. But this is also true in other states. I've heard people that have called. If a person calls an attorney, if they call a witness, if they call somebody during the observation period, during the 30-minute waiting period when they're allowed to call for an attorney or a witness, regardless of who it is that they call, if they say the person on the other end of the line told me to refuse, huge point to bring out. Huge point to bring out. If they at any point tell the officer, you know, my third cousin twice removed, who lives in Alaska, told me I should refuse testing, perhaps that is really terrible advice, right? And you know, not very trustworthy advice to follow in this kind of a high stakes situation. But if they communicate to the officer at any point prior to breath testing that I have heard, really afterwards, actually it doesn't really make any difference when it's communicated. If they've heard, I've been told by an attorney, I've been told by a friend, I've been told by whoever it is that I should refuse to give a breath test, that is a huge point of emphasis to bring out in front of the judge or the jury, because this is a split-second decision being made generally by somebody with very limited knowledge. So maybe did they rely on bad advice in terms of deciding to refuse chemical testing? Maybe they did, but they had a legitimate reason because they didn't have anything else to go off of. Literally, the only other person that is telling them to, oh, you should take the test, is the officer sitting on the other side of the table that has already put them in handcuffs and is planning to criminally prosecute them for this charge. So there's not a whole lot of trust kind of sitting across the table. And this doesn't matter whether the officer has good intentions or bad intentions. I think some officers are really trying to coax individuals into taking a breath test, not necessarily because they care about the number that gets spat out, but because they legitimately don't want the person's license to be revoked. Hey, you are going to lose your license. Like, I mean, just think about that. You know, there are people with good intentions, officers with good intentions, but regardless of what their intentions are, they're literally sitting on the proverbial opposite side of the table, right? That this is a person that is in an adversarial position from a trust standpoint. And so whoever it is that the individual deciding whether or not to blow, whether or not to allow a needle to get stuck in their arm, whoever it is that they're relying on in terms of deciding, should I refuse the test or take the test, that is important to bring out to the judge or jury if they have in fact received advice. And I've said in the courtroom many a time, you know, this would not be the advice that I would have given under these circumstances, but it doesn't matter. That was what was in the mind of my client at the time. You've got to look at the refusal in the context of all the other evidence, and you've heard all of this evidence about lack of impairment, about signs of sobriety that were seen. And when it came time to take this test, my client was informed by the officer he had the right to refuse to take the test. He had been told by his cousin out of state that was the right move. He didn't know what to do, and he, you know, went with that advice. You know, but we're now playing Monday morning quarterback and looking back at that decision that's being made in a split second on relatively limited information. So make sure to bring that out. Again, and kind of last point to kind of think about, bring out, there are sometimes other crimes that could be involved in addition to driving while impaired that somebody might not want to blow. So for instance, if you have a client that is underage and they go to the station, you've got somebody that's 19 years old. They are told, here are your rights related to chemical analysis, and they refuse. Should that refusal show that they're impaired? Well, I would submit to the court that should be very much limited, because what are they told? And this also applies to a CDL driver. So we'll just go ahead and kill two birds with one stone with this, as opposed to kind of going through it separately. They are told under 20-16.2a subsection 4, your driving privilege will be revoked for at least 30 days if you refuse any test, or the test result is 0.08 or more, And here's the big part: 0.04 or more if you are driving a commercial vehicle, or 0.01 or more if you are under the age of 21, right? So they're told your driver's license is going to be revoked if you are 0.01 or more on a PBT, on a breath test. And again, that could be used not only in terms of revocation, but an actual element of the charge of driving after consuming being less than 21. Open container charge, any amount of alcohol being in your system, carrying concealed weapon charge where they've got any amount of alcohol in their system. All of these things might be playing through this person's head in terms of why they are deciding not to take the test. So I think bring out to the judge or to the jury any, again, actually expressed motivations for not taking the test, regardless of whether they are found on the best legal advice that there is, or whether they're coming from pretty shady advice. This is what the person has before them in this limited amount of time to take the test. Or if there's not an express motivation for taking the test, give some of these as ideas potentially for not taking the test, as addition or as possible motivators. Because again, I think that what most people see is if the officer says, or not most people, most judges or a lot of judges see, if there is a request by the officer to submit to a breath test or a blood test, and the person just says, I'm exercising my right not to take the test, but then there's no explanation as to why. It's just, well, it must be because there's an alcohol concentration 0.08 or greater. Bring out some of these other motivators that exist. So I think the main key to focus on with regards to this kind of last point, in terms of this being evidence that is admissible, that the refusal is admissible evidence under 20-139.1, remind the judge or the jury that it is one piece of evidence to be looked at in the context of all the evidence. Particularly helpful if you've got video and your client looks pretty good on video. Look at this one piece of evidence in the context of all the other evidence, because what is the state trying to prove in a pure refusal case? Not first result in second refusal, not where there's a refusal of a blood test and then the state goes and gets a search warrant and ultimately draws blood. In a kind of standard refusal case where there's no chemical result, no 0.08 or greater blood or breath, what are they trying to prove? Appreciable impairment. Appreciable impairment. That the signs and indicators of your client's behavior show that they're appreciably impaired. If you've got video, if you've got good results on the SFSTs, you got good results in terms of lack of notations of signs of impairment. This is one piece of evidence that should be looked at in the context of all of that evidence of sobriety or of all of the lack of evidence of impairment. Make sure you use the rationale and the instruction that is given to the jury in terms of looking at this one individual piece of evidence in the overall context of what is going on, that you cannot make your decision. You cannot base your decision on this one piece of evidence. You're not allowed to base it on the one piece of evidence. It would be improper to look at just this one piece of evidence, ignoring all of the other evidence. Make sure you bring that out to the judge or to the jury. Hope this information has been helpful to you, and I look forward to speaking with you again next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.